Across the complex jurisdictional landscape of settler colonial Canada's particular version of federalism, provincial and federal governments are frequently in conflict over the constitutional authority concerning Indigenous peoples. So within this political economic context, Indigenous labor and its regulation are emerging as ongoing sites of contestation and struggle. So our research critically examines a body of case law, as I mentioned, related to this concept, the core of Indianness, which is a contested legal concept that courts and tribunals use to determine which Indigenous enterprises and workers fall within the exclusive authority of the federal government. So our presentation briefly first revisits the precedent-setting case in this area, 4B manufacturing versus the United Garment Workers of America. And we then discuss the functional test that first developed in this case to determine jurisdiction over Indigenous labor and how it came to be applied in subsequent cases. As we argue, it's notable that the practice determining the core of Indianness was first developed in a case involving a private sector employer because of the ways that that concept and test were later then deployed in cases dealing with what we might term the Indigenous public sector. So in short, because Indigenous workers performing social service functions in their own organizations are not employees of the federal or provincial government, their labor relations are typically governed by labor relations acts that are crafted for private sector labor relations. So as we argue, the private-public dichotomy fits uneasily in Indigenous contexts and then generates additional problems for Indigenous workers who are trying to unionize and collectively bargain. So the first application of the core of Indianness by a court appeared in this case, as I mentioned, 4B manufacturing, which involved a unionization effort at an Indigenous-owned shoe manufacturer on the Tyendinaga Reserve in Ontario, which was contracted to the Bata Shoe Company, the business was. This was in the late 1970s. So in this case, the Supreme Court of Canada determined that the regulation of Indigenous labor relations in this private sector firm did not concern quote unquote Indianness, and therefore was a matter of provincial jurisdiction, right? Not a responsibility of the federal government. The employer had pursued federal jurisdiction in part as a union avoidance tactic, but deployed a series of arguments concerning the Indianness of the firm and therefore its federal jurisdiction. And those arguments would be taken up in later cases by employers. So according to the employer as a quote unquote Indian enterprise, 4B's labor relations were a matter of federal jurisdiction owing to the federal government's constitutional authority over Indigenous people via section 9124 of the Constitution. That's the portion that refers to quote unquote Indians in lands reserved for Indians. But the majority at the Supreme Court disagreed and determined that instead 4B was a private sector enterprise like any other and therefore was subject to provincial laws of general application, which include the Ontario Labor Relations Act. So 4B's precedent shaped the legal landscape of Indigenous labor relations, but not without conflict and ambiguity. And as you'll hear in the next presentation, for a period after 4B, courts and tribunals interpreted this case to mean that it was the practical activities of an enterprise that determined federal or provincial jurisdiction. And accordingly, they reasoned that if an enterprise, for example, an Indigenous operated school on a reserve, was primarily concerned with reproducing Indigenous people, that it was therefore within the federal jurisdiction because its operations went to the core of Indianness. The practical activity of the school would be therefore, educating Indigenous children. The Indigenous character of the enterprise mattered. However, this broad interpretation of the core of Indianness lasted only so long. And as we'll discuss, soon courts reinterpreted the meaning of 4B and the functional test. Instead, the question would revolve around the immediate practical activities of the workplace and whether those normally fall within provincial jurisdiction. So if we take a school again as the example, schools are provincial. And so no different in the case of Indigenous people, or that's how they came to determine it. So in the process, the core of Indianness was narrowed considerably as many Indigenous public sector functions were reinterpreted as being outside of the core of Indianness and therefore not matters of federal jurisdiction or federal responsibility. So before we discuss that process further, I want to briefly review the nature of the functional test that I mentioned before. So a central part of the precedent that was set by 4B was the use of this functional test for determining what's relevant to the core of Indianness, to then identify which level of government has jurisdiction over Indigenous enterprises and thus governs their labor and employment relations. In upholding the decision of the lower courts and maintaining that the employer's operations were in fact within provincial jurisdiction, the majority at the Supreme Court, led by Justice Beath, relied on this functional test, which consists of two steps. So the first step involves querying the primary focus or activities of an enterprise to determine if they normally fall within provincial jurisdiction, as I mentioned before. And then the second step determines whether the relevant provincial law, so in this case, the Ontario Labor Relations Act or any provincial labor relations act, impairs the status or capacity of Indians, quote. So only if the first step is inconclusive is the second step then taken, or the second question asked. So speaking for the majority, Beath stated that exclusive federal jurisdiction over labor relations arises only if it can be shown that such jurisdiction forms an integral part of primary federal jurisdiction over some federal object. So in this, the justice was distinguishing the object of the functional test from the people against whom it's applied, right? Separating the enterprise and its functions from the identities of employers and employees. So therefore, the test only applied to the practical activities and not to the particular persons or people. In other words, the Indigenous identity or even Indian status of the business owners, workers, or community members had no bearing on what the business produced and was therefore not appropriate for determining jurisdiction. So the Supreme Court majority argued that nothing inherent in the operation of 4B made it a particularly, quote, Indian firm, and therefore the business was subject to provincial laws and regulations. And I'll let James take it from here.
So as Adam mentioned, in the decades that followed, labor boards and courts refined the Supreme Court of Canada's interpretation of the core of Indianness, as well as the functional test, and applied these to other labor relations cases and employment standards cases in public and quasi-public sector cases. These included healthcare, education, and social service agencies, the transference of the functional test from private to public sector workplaces, or from a for-profit manufacturing firm, thinking back to 4B, to workplaces engaged in not-for-profit care work is really notable and kind of something we dig more into in the forthcoming paper on this panel. In cases spanning from the 1980s to the early 2000s, courts used the function test to apply the core of Indianness broadly. In the process, determining that federal labor boards had jurisdiction to hear cases involving Indigenous social service workplaces. So this kind of reading in and applying the test to a newer jurisdiction. Interestingly, courts and tribunals reasoned that the function of such workplaces was the reproduction of Indigenous communities. An application of the functional test, they argued, that was consistent with the precedent set in 4B. So as you'll hear in the next paper, in the late 2000s, another set of cases began to repurpose the functional test, narrowing the range of workplaces that touch on the core of Indianness. So this kind of contraction of federal jurisdiction, the application of the Canada Labor Code. And thus expanding the reach of provincial legislation and labor boards to Indigenous-run public and not-for-profit workplaces. In these later cases, the focus of the functional test moved away from querying the extent to which practical activities of particular workplaces touch on the core of Indianness, and thus turned instead to strictly assessing if workplace activities normally fall within provincial jurisdiction. So this kind of big set of shifts that we can observe within the case law itself. For example, by demonstrating that child and family services or healthcare services are not special or unique to Indigenous peoples, and thereby not integrally related to what makes, quoting here, Indians and lands reserved for Indians, thinking of section 9124 of the 1867 Constitution, of federal area of responsibility. So in this way, the functional test was used to exclude Indigenous labor of social reproduction from being considered inherent to cultural reproduction of Indigenous peoples, and by extension, from their special status within Canada's settler colonial system of federalism. So I'm now going to turn to address how these post-4B cases involving the Indigenous public sector or not-for-profit workplaces troubled the distinction between public and private functions as understood in other Canadian workplaces. The precedent set by 4B and the functional test came to highlight an ambiguity between public and private sector workplaces and labor relations governance in Indigenous contexts. So courts and tribunals post 4B believe themselves to be applying the functional test and the core of Indianness faithfully in cases involving Indigenous social services, or what would typically be public sector workplaces in non-Indigenous contexts. However, we argue Indigenous employment relations and overlapping governance regimes pose a challenge to the analytical distinction between public and private sector workplaces and functions. In short, Indigenous workers performing what would in non-Indigenous spaces be considered public sector work are often employed by bands, organizations at arm's length from First Nations governments. So they're not provincial or federal government agencies. When it comes to assessing collective bargaining rights, though, legislation designed to facilitate labor relations in Indigenous public sector workplaces and their unique jurisdictional location kind of troubles this distinction, both due to their placement within the Canada's constitutional order and the complex legal identity that complicate this public-private dichotomy. So to clarify this, Indigenous workers seeking unionization in federal jurisdiction are governed by Part 1 of the Canadian Labour Code, rather than Public Service Labor Relations Acts, or the Public Service Labor Relations Act. In other words, for the purposes of labor relations, all Indigenous workers are treated as private sector, insofar as Indigenous workers performing public, not-for-profit care work in Indigenous operated workplaces are not direct employees of settler governments. In this sense, the ambiguity between public and private sectors in Indigenous contexts combines with more general uncertainty over provincial and federal jurisdiction, and can introduce complications and delays into the union certification process, as unions and employers seek to determine the appropriate jurisdiction, provincial or federal or provincial, that governs their labor relations. As in 4B, this jurisdictional and sectoral confusion can provide employers with an opportunity to avoid or delay unionization with labor boards and other court appeals, so that it can introduce this confusion over what legal mechanism, federal or provincial, they're trying to use to actually secure union certification, allowing the employer to potentially block this. As we argue, 4B and its functional test continues to shape the jurisdictional landscape across a wide swath of cases. I'm working on a paper right now on casino governance and how that's been a murky and contested area, but even more broadly, education, as we'll get to in the next paper. In particular, the initial application of the core of Indianness and the functional test in a case involving a private sector manufacturing enterprise influenced the way the courts and tribunals used these legal tools in the years following. So finally, we claim that because the distinction between public and private sector workplaces in Canada applies ambiguously in Indigenous contexts, this can introduce complications and delays in union certification processes. These legal and policy legacies continue to render jurisdictional uncertainty in many Indigenous workplaces. Thanks very much. I'll conclude there and turn the floor over.